Last Monday, the 24th of May 2021, His Honour Judge Dight gave judgment orally in another unopposed lease renewal. I acted for the tenant, led by Martin Hutchings QC and instructed by Kirsty Black at Shoesmiths. I've since been asked quite a few times what the key takeaways are from this decision, so I thought I'd make this video whilst we wait for the judgment to be transcribed. So the outline of the case, it's just one case in 123 unopposed lease renewals as part of the same portfolio between the same landlord and the same tenant. They all arise out of a single sale and leaseback deal in 2005, which is why so many came up for renewal all at once. Now the issues were: 1, the length of term and break; 2, whether the rent should be subject to fixed annual increases of 1.5%, and if not, whether there should be a rent review clause and what kind; and thirdly, rent and also interim rent, which was agreed to follow the rent, so we say no more about that. Now, since we've got no fewer than 4 further trials currently listed to deal with this portfolio, this case is very much ongoing. So I'm going to try and describe the highlights from the judgment as best I can and resist the urge to comment too much, which is always tricky. So here are my 4 highlights from the judgment. So first, length of term and break. So the landlord wanted a 10-year unbroken term. The tenant wanted a 5-year term with a 3-year break. And I'm pleased to say the tenant won. There are no particular legal points to come out of this decision in general. It's all pretty conventional, but there was one nice point about the so-called starting point for the break for purposes of the O'May test, where the current lease had annual breaks, but the current lease also provided that the annual breaks weren't going to form part of any renewal lease. And the judge concluded that the starting point was annual breaks nonetheless. We submitted that the attempt in the current lease to control the terms of the renewal lease would be contrary to the anti-avoidance provisions of the Act. The judge was, though, at pains to make clear that he was carrying out a balancing act between the reasonable interests of the landlord and the reasonable interests of the tenant. And a key point of general application from this decision that really did influence the judge was the tenant's in general need for flexibility in the current disrupted retail market. Tenants generally are seeking shorter and shorter terms and shorter breaks to account for the uncertainty of future trading conditions in this post-pandemic world, and that influenced the decision. Right, so the second highlight was fixed annual rent increases. So the current lease provided for 1.5% fixed annual increases to the rent. The landlord wanted those increases to continue. The tenant wanted no such increases. Now, the key point of principle here is that in reliance upon a case called Faulkner Chelsea in the Court of Appeal, the judge held that fixed rental increases were a matter of section 34.1 of the Act and not section 34.3. So as a reminder, section 34.1 is the usual clause which is used to set rent, and it's based upon what is available in the market. You get valuation evidence in respect of it. Section 34.3, on the other hand, is the usual clause used to insert rent review clauses into your new lease. Now, although the position is a bit opaque, it's generally regarded that section 34.3 isn't based upon what's available in the market, but instead is a matter of the court's discretion. So it's up to them, and I'll explain why I say that a little bit more when we come on to my third highlight. Now, the judge held that if he were to set fixed rental increases, he was just setting the rent under section 34.1 in a slightly different way. The difference in section 34.3 with rent review clauses is that there the court doesn't know what the future rent might be. It's just setting a mechanism by which that future rent might be determined. But in this case, he knew that the rent was going to be whatever it was in the first year, and he knew that it was going to be 1.5% more in the second year, 1.5% more again in the third year, and so on. So, having concluded that fixed rental increases like that came within section 34.1, the judge didn't have a discretion, but instead he had to follow the market, just like he would with rent. And since fixed rental increases are very rare in the market, and in fact that none of our comparables had fixed rental increases, the judge held that this new lease shouldn't have fixed rental increases either. Okay, so the third highlight is rent review. So the judge said that had he ordered a 10-year term, he would have ordered a rent review clause at year 5. So far, so good. However, the landlord wanted that to be upwards only, but the tenant wanted it to be an either way rent review clause. Now, almost universally, the market has upwards only clauses. But if you go to something like Reynolds and Clark, you'll see that almost universally the courts order either way rent review clauses. And the reason why they do that is they are generally regarded as fair to both parties. Why should the tenant bear the risk of rising rents but not get the benefit of falling rents? And interestingly, this is a good example of why or how the courts are treating section 34(3) as a discretion and not something governed by what happens in the market, because they're identifying that the market practice is universally upwards only, but then going against it. And if you want to see an example of that, His Honour Judge Sagerson's decision in Dukeminster is a good place to go looking. However, in our case, His Honour Judge Dight said that he would have ordered upwards only rent review clauses in this case, rather bucking the trend. So every time we think we have something reasonably certain about this Act, we get another little surprise like this. Okay, lastly, my fourth highlight, rent and in particular rent-free periods. This is the most techie point, but it's also potentially of the widest application, so I'll try and deal with it very briefly. Often a comparable which is used to ascertain the appropriate rent per square foot for the subject premises will have a rent-free period. In 1954 Act renewals, the courts order day one rents, i.e. rents payable from the first day without a rent-free period. Although it's not at all clear that they have to do that, but that's for another day. Now, in such a case where you have a day one rent, the comparable with a rent-free needs to be adjusted to take the comparable's headline rent and get to your net effective rent to take into account that rent-free period. And that's done by spreading or amortising the rent-free period over the term of the lease. So take an example. Suppose there's a headline rent of £100,000 for a term of 10 years with a rent-free period of 12 months. The net effective day one rent will be £90,000 because you're spreading that 12-month rent-free period over 10 years. Now, the issue in this case concerns how much of the rent-free period should be spread. In the retail market, it's common for tenants to be granted 3 months rent-free period to account for the period of time it takes for them to fit the premises out. So of my example 12-month rent-free period, it can be said that only 9 months of it is pure incentive because the first 3 months reflects a period when the tenant can't trade from the premises. In a 1954 Act renewal, normally the sitting tenant won't carry out a new fit out, so will be able to trade from day one. And there is a raging debate here. On the one hand, should only 9 months of the rent-free period in your comparable be amortised to reflect the reality that the tenant will be trading from day one at the subject premises? Or should the whole of the 12-month rent-free period be spread to get your net effective rent, because that is what would be agreed in the open market between a hypothetical tenant and a hypothetical landlord, and that is what Section 34 is about. Now, it's quite a complex legal issue about the construction of Section 34. There's no binding authority on it. All of the recent county court decisions have favoured tenants and amortised the whole of the rent-free period. But again, His Honour Judge Dight has bucked that trend and found in favour of the landlord. So if a comparable has a rent-free period, the first 3 months of that are ignored for valuation purposes. Now, I would love to comment more on that, but as I say, since the cases are ongoing, I won't. The point for now is that there is now greater uncertainty on this issue, unfortunately, and it's all to play for in other cases, since none of these county court decisions are binding in other cases in any event. So I hope you found that rundown helpful. The judgment will be available at some point, but if you have any questions, please do get in touch. Thanks for listening.